Okay. Hello, my name is Dale Adams of Planning Ahead of Time, and today again I'm speaking with Jay, this time with relation to LPAs. So Jay, would you like to introduce yourself again?
Hi there, I'm Jay Parmer. I'm a partner at a firm called Paradigm Wills and Legal Services. We're a step qualified firm specializing in wills, trust, lasting powers of attorney, probate, and inheritance tax planning. And today we'd like to support you by talking about lasting powers of attorney.
Yeah, well, in our last conversation, we spoke quite a lot about wills, but I also think that lasting powers are really important, and a lot of people don't understand just how important they are. So I was hoping you could share some information on that.
100%. Yeah. So they are very popular documents, and people don't seem to understand them as much as they should do. A lot of people think that once a lasting power of attorney is created, it's for people to use after their family members have passed away. But what they need to understand is lasting power of attorney will look after your requirements while you're alive in the event that you lose mental or physical capacity. Whereas once you die, your lasting power of attorney will actually die with you. And then that's when your will come into place. So they both are important documents and they both work hand in hand, but one will work for you when you're alive, which is a lasting power of attorney. And then the other one will kick in once you pass away, which is your will that you've created, if you've created a will.
Yeah. Well, I didn't realize the importance, like others, I suppose, of the lasting power of attorney until my mum got dementia. And then it was being asked for, and we hadn't got it for health and welfare because there's obviously two. One is
That's
for
right.
finance. Again, I'm sure this is something you'll go into, but we'd got the finance one because it was done when the will was created. So it was all part of the package that was provided to my parents.
Sure.
The health and welfare one wasn't. Subsequent to my mom dying, we've now got my dad's in place and I have one in place. But I think people don't realize, as you say, that actually that's what you need when you're coming to the end of your life and you don't have the ability to speak for yourself. Your will is when you've died and don't have, therefore, the ability to speak for yourself. But they're quite different.
They are completely different, but both are created in the same sort of method, which is the person who's looking to create a power of attorney or a will, they need to have full mental capacity at that time. So they've got to be able to express their wishes, especially with a lasting power of attorney, because it's really important that you have your wits about you at that time to be able to decide on who is going to be able to step in and become your attorney. The attorney is that person who's going to be you at that time when you can't function. It could be that you lost mental capacity, you can't think for yourself at that time. You're not able to speak at the time because you've had some kind of accident, you're in a coma, those sort of situations. And you need someone to be able to step in and make sure life still continues, especially if you're a family and you've got young children, maybe as an example. Maybe you're the main breadwinner of the house, and most of the money is tied up into your bank accounts. If something was to happen to you at that point, people automatically think, well, that's my wife, she'll be able to step in and she'll be able to go into my bank account and withdraw the money. That isn't the case. You know, you've got to think about GDPR as an example. If that person had access to the account, they'll be named on the account and they should be able to have access to that. There have been cases where couples have had joint accounts and the bank have had the decision to freeze the joint account because one person is incapacitated at that time. It could be that the couple have fallen out and the person that isn't incapacitated may want to take all the money out, maybe run away with the money. So to protect that person, the banks have decided to freeze the accounts. Having a lasting power of attorney in place, especially a property and finance power of attorney, will allow your appointed attorneys to ensure that life still continues at that time. Make sure bills are being paid, make sure any kind of interaction with your mortgage company can be carried on, insurance companies, your bills, but even little simple things like having a savings account and you have a 12-month interest rate on there, the interest rate is now dropped and you want to ensure that your money is still earning you the best amount of interest possible. Your attorney can then look at other accounts and then switch it to a better savings account for you. These are little simple things that you don't really think about at the time, but are things that need to be managed when you've not got the will to be able to do that because you've had an accident or you've lost capacity during that time. So they are really important. And as you mentioned, Dale, there are two documents in place. So the property and finance, but also the health and welfare. You've got to think about if your health deteriorates, who would you want to be able to make the decision for you? The NHS and the social services could come in, and then they can make demands and they can take control. But are they the best person to create those kind of needs for you at that point? Do they know you well enough to be able to understand what your wishes are of what could happen at that point, especially at a time where you can't actually speak? So by having a health and welfare power of attorney in place, you're giving the attorney the powers to be able to make decisions on your healthcare, what your medication looks like, what your care treatment looks like. One of the examples I usually use with my clients is when COVID happened, the vaccination was created, and you had a population which wanted the vaccination because they think that that's the right thing to do. Then you have a population that doesn't want the vaccination. Now, let's say, for instance, you're in a coma and the NHS come back to you and say, well, we've got this vaccination, we're going to give that to you. And you're one of the people that don't want to actually have that vaccination. You can't speak, and the NHS are just going to go gung-ho and they're going to give you that vaccination. By having an attorney, letting them know what your wishes are, they can then intervene and then say to the NHS at that time, well, no, we've had this conversation, and as their attorney, I'm telling you that they wouldn't want to have this vaccination, and for that reason alone, we won't administer that a vaccination to them. And it allows your family to make those kind of calls, conversations with the NHS at that time about what your treatment looks like at that point as well, even to the point of what your end of care treatment looks like as well. So if you're in a coma and the doctor say to you, you're going to come back into a vegetative state, and you've had that conversation with your family saying that I don't want to come back at that point, and I'm happy for you to turn my machine off at that point, then your attorney can have those kind of powers. But it's such an emotional thing to be able to do, especially when it's your children that are left with that kind of decision. So you need to have these kind of conversations with the children and make sure that they're aware of all of this. Otherwise, the right things won't happen.
Yeah. Well, I have a client who I've been working with, and it was simple things. Sky TV, they were on a package that was quite high because when the husband was living there, he had various channels. He went into a care home, lost capacity, and then it was simply nobody, because everything was in his name rather than in joint names. It was trying to organise LPAs and actually get the information changed. And it was just a Sky TV package. They would not speak to anybody without obviously receiving the LPA. Then because the LPA had been done so long ago, everybody wants the original, which in itself is a problem. Although, of course, you can get it certified and you can get that done locally, which I think is something that would be nice for you to confirm. And now there's obviously the way of sending it through a digital code, although that does seem to be very new. And we had problems with certain companies just not being able to use that service. But I do feel that having it in place, again, it seems that the finance side is done maybe with wills, but the emotional, but it is the emotional side to me, the spiritual side. It's what would you want? What would you want done with yourself, your body? How would you want to be cared for? That one seems to be left really when people are dealing with the financial side. But the finances are so important, because it is the little things. It's your gas, it's your electric, it's being able to do insurances, bank accounts, all of the things that you actually need to run a home. And especially if your home is not in joint names. And that was the problem that we had. And yet they were an older couple. They'd been married 50 odd years. It just happened that everything was in his name.
That's right. Yeah. And these kind of things still happen to this day and age. One of the things that we get queried about is, why do you charge for powers of attorney where I can go online to the Office of Public Guardian, I can download the form, complete it, and just pay the £82 registration fee? And they are right, they can do that. And we do advise our clients of that you can do that process. But the dilemma there is that if you've got an estate where there's a house involved, there's a lot of money involved, well, you've got to ensure that there's certain clauses that have been put into the lasting power of attorney. However, with the Office of Public Guardian, they will just give you a blank template. And 99% of the people who complete that document don't know how to complete it, so they won't put any clauses in. Now, what will happen is the time arises where the power of attorney needs to be used. So they go to use it, and then the bank or the mortgage company will refuse it, saying that, well, no, you haven't got the powers to be able to carry out these certain transactions. So then they look to a company and then see what can be done at this point. Do we need to create a new power of attorney? Now, as long as the client has got capacity, we'll be able to create a brand new power of attorney for them. However, just to make you aware, the Office of Public Guardians, since COVID, are very behind at creating these documents, and it's taking them 6 months to register the documents. So 6 months to create your documents. We can create the documents within a matter of time, but to register the document, it has to go through the Office of Public Guardian. This is taking so long at the moment, and 6 months is the wait period. So at the time when you need the document, you're not going to have that document available. Now, there is an alternative at that point if you don't have a power of attorney called a court of protection. However, you can apply for the court of protection, but it will only grant the attorney the powers of property and finance only. And this can take up to 10 months to create that document as well. It has to go through the courts. It's going to be much more expensive than a power of attorney is. It's going to have additional legal fees attached to them, and it can have annual fees attached to them as well as potentially the Office of Public Guardians having to monitor you on a yearly basis to make sure that the attorneys are doing things correctly. So this one is going to be really tiring for the attorneys and for the family to create that. So having a power of attorney in place is going to be the most appropriate, most cost-effective way of having that in place. We, during COVID, my wife had to have an operation on her heart, and she was a bit concerned that she may not, the operation could have its complications. So she was worried that if anything happened, so what would happen? So we created a power of attorney for her at that time. Luckily, we created it just in time before she goes into to have her operation. Now, luckily for us, we never needed to use the power of attorney. However, it was needed to be there as a safeguard just in case anything was to happen to her. If she lost capacity, she lost her mobility, those sorts of situations would allow me to then, as her attorney, to be able to step in and then control those finances on her behalf. Now, one of the biggest dilemmas that clients are having is, just like I said, it takes 6 months to register the document. So clients are saying, well, can it be done any quicker? The simple answer to that is no, unless you're coming to end of life. At that point, by having a doctor's letter, we can send that off with your documents, and that could potentially speed up the process. But that can still take up to between 7 to 10 weeks for the Office of Public Guardians to still register the document. There is something in between all of that called a general power of attorney for property and finance that can be created. That can be certified immediately by our company and can be created immediately, and that can be used for property and finance. However, it would only be active while the donor has capacity, mental capacity. The day they lose mental capacity, that document then fails. So it'll be important to have the general power of attorney to act on it immediately, but secondly, to also create the power of attorneys as well for in the event that the donor does lose capacity.
Okay,
so there are various options there for the clients.
Yeah, so the general power of attorney is something that you create as a company. That a person can put into place, but they have to have capacity. So is it that they have capacity but not capability?
That's right. So we had a situation just recently where the elderly lady, full mental capacity, she could speak to us, she could give me instructions, and she talked to me all day long about what she's looking to do and why she wants to do it. And her goal was that she had assets in India that needed to be managed, but she was too frail to be able to walk, to go over to India and to be able to conduct those kind of tasks. So she wanted to create a power of attorney so that her son and her granddaughter could then go over to India, manage all those affairs, and then be able to conduct all that for her on her behalf. However, they came to me probably a month before they were to fly out, and I go, we can create a power of attorney, but it won't be created in time for what you require it to be done. So we could offer you the option of a general power of attorney. We create the general power of attorney. It was certified. The clients had taken it over to India, carried out all of their transactions, and were able to complete it on behalf of mum. And then all of the money of the property and land that was sold went straight into mum's account. And so she can then manage it from here afterwards.
I do think that's a good thing, especially for some of the, if you like, the older generation, because so much now is digitized. And it's a problem that I've noticed with a couple of clients is the fact, again, they have capability, they have capacity, but they don't have capability because they just don't know how to do it. To the point that one client, actually, we had her removed from the lasting power of attorney to allow the children to take over, because she had power of attorney for her husband. This is the same person who'd gone into care. But she basically couldn't deal with what was required. So we had her removed, and then the children were able to basically take over because they weren't all sort of working, if you like, I know it's I can't say the word properly, severably or independently. So
Independently, yeah.
Yeah, and
Jointly or severally, yeah. So you can have powers of attorney set up in a way where if you've got two attorneys, both attorneys need to be available to then be able to sign. It's something that we go against, because we'll advise the client that the dilemma is going to be is that, let's say one child passes away, then your lasting power of attorney fails at that point, or one of the attorneys is flown away somewhere, and until they come back, we can't actually action anything for you. So to get them to work independently will probably be a better situation than jointly. Now, normally, if you're going to do, both people need to sign at that point, there might be a trust factor involved in this kind of situation. And I would spend a lot of time with the client saying that you really need to think about who your attorneys are going to be. Sometimes they say they're children, and I go, okay, well, think about your children, think about their traits, and are they the most trustworthy people to be able to carry out your actions? Because they are going to be able to access your bank accounts, withdraw money if they wanted to. Do you trust your kids enough to be able to do it? Now, 9.5 out of 10 times, yes, they do trust their kids, and the kids are great. But you do get that 0.5% where the kids are probably off the rails a bit, they are money orientated, and they could take advantage. We've seen these kind of situations happen to clients before. So it's so important for us to be able to make them aware that they have to appoint the right attorneys in place. And it's so important that they carefully think about who those people are going to be.
I think that's exactly the same, Jay, for whether it's finance or health, because I know with mine, I actually do have my children on my LPA or both. But on the health, I've also got my best friend who's a nurse, because she has the knowledge that my children don't. And it's a case of, well, if needs be, if they can't make that decision between them, not speak very well today, if they can't make that decision between them, you also have that circumstance. If they're going to debate and argue, then maybe there needs to be somebody who has the knowledge and the expertise again in your sort of group who could do that. I do
I agree, and your friend is a good choice as well, because not only because she's a nurse, but she also knows you as a friend as well, and should understand what your wishes are, what you like, what you don't like, and she'll be able to make those kind of important decisions for you, especially when it comes to healthcare. And with some clients, what you will find is they'll have a set of people that will manage their property and finance, and then the set of attorneys that will be managing their health and care needs as well. So they can have different attorneys between them. They don't have to be the same because they put it on property and finance. It doesn't have to carry over to the health and welfare. You've got different people with different responsibilities because of their different capabilities.
And again, sometimes I think having someone who's slightly detached from the situation, because of, again, of the emotional side of it, if you've got somebody who's there are people that just want to keep people alive just because they don't want to let them go. And there is a fear of letting somebody go, a fear of letting somebody die. And that's totally understandable. But also having the discussions before it happens makes you know, would this person want to continue if this is what their life is going to look like? And I think that's very important, to have somebody also who's strong enough to make that decision and say, no, at this point we have to abide by our wishes and let the person go. This is me talking from experience with my mum, but that was a circumstance, and it was a case of, no, actually it's time to accept that we need to let her go now. And I think
and you've got to remember that she's not suffering anymore as well, isn't she?
But again, you have to have somebody that will put the wishes of you, if it's your LPA, ahead of their own needs and wants, really.
That's right. And this is what I mean.
Keep people alive as long as possible, but it's not always what needs to happen.
That's right. I get clients sometimes, yes, they have children, but they've probably got a brother or sister or maybe a cousin or an uncle that is equipped to deal with finances, and they go, this is going to be the best person to manage my finances. but I can put my children as reserve attorneys in the event that my brother or whoever I've appointed can't carry out the actions or is not about at that time. So, there's multiple options that we need to cover with the clients. They can put as many attorneys as they want on there, but you've got to be quite smart about who you're putting onto them. We're not just putting these people on for the sake of putting them on. These are people that can then access your accounts and then be able to manage things on your behalf. And sometimes they don't have to ask, they can just go in and do that. It doesn't mean that they're doing the right thing. They should only be acting on your behalf when it's required, not before that. Unfortunately, in the past, there has been times where people have created lasting powers of attorney and they put the wrong people down as the attorney, and these people have taken advantage. And sometimes it has been their children, and they've taken money out of the client's account, left them penniless, borrowed money against the property. Those sort of situations have occurred, and that's why it's important to have that kind of conversation. Say, pick the right attorney.
I suppose again, it comes down to what you would do when you have full capacity in your everyday life. Are they people you would trust to hand over that information? Because actually, that's exactly what you're doing, isn't it?
Exactly.
I liked it earlier when you said, they are acting as you. So in that moment, they have to think, what would you want? And they've got to try and carry out your wishes. So if you wouldn't give that responsibility to them in your everyday life, then it's certainly something that you want to be doing for when you don't have capacity, or again, after you've died.
Yeah, and we've had situations where the clients haven't actually got anybody they can have as their attorney. So sometimes what they'll do is that they'll appoint maybe a firm. They could appoint our firm. They may have another firm in place that they might want to appoint. It could be their accountant. It could be the independent financial advisor that they work with. They might appoint them to then manage on their behalf. So there are other options there, but it's exhaust all those avenues to make sure that you've appointed the right people.
That's really interesting, Joe, because there will be obviously a lot of people out there who don't really have anybody to give it to. So as a firm, that's something that you would take on behalf of your clients.
Yeah, we've done that previously for clients before as well. So we could then act as the attorney on their behalf for them. Yeah. Again, it's, the clients have got to have trust in these kind of people, and the companies that they're going to be working with. There's obviously always horror stories that you read in the papers, you read on the internet, where clients have trusted a firm and then the firm have taken advantage of them. So it's important that the clients will do some kind of due diligence on the firm as well to make sure that it's a legitimate firm, what's their track record like, and they're going to be the right people again to be appointed as the attorneys.
I think there's so much to think about. And I do think that people leave it much too late or too long before they start thinking about it. As I said, for you and I both agreed in our chat before about wills that you need to be starting to think about it early. For me, once I started in the end of life work and looking at the services post and pre-death, then I started to find out a lot more about LPAs, but it all became very prevalent, obviously, while we went through my mum's illness. And that was so rapid that we just didn't realize until it was too late that we needed this in place. And then we hadn't got it in place. But I do think that it's quite important for anybody, actually, and while you're healthy, to be looking at this as something that's holistic, where you say, well, this is everything I need in place for when I lose capacity towards my end of life and then post-death, and have it all in place. And I know that it costs quite a bit to get that all in place up front, but I do think it can save so much time, money, and stress to have it all in place.
Yeah, when it comes to the money side of things, yeah, of course, finances are going to be tight for a lot of people at times as well. But you've got to ask yourself the question, what are you actually comparing the cost to? Because it's not something that you've ever done before. And you've got to think about, what are you going to get out of actually paying that kind of cost? People pay insurances and not knowing that, is that insurance ever going to have to be used? But you're paying for those insurances. And if you think about it, a lasting power of attorney is a form of insurance that you're taking out, but it's better than life insurance because it's going to allow people to be able to make sure that life still continues for you at a time where you can't. So it is important to do that. as human beings, people are, you know, like you've said, it's about being reactive, because you've either seen something that's happened to someone else close to you, or something that's happened to you in your lifetime that's made you act, I've got to get this done. But we've got to start thinking a bit proactive in the UK, and think about, how do we start preparing for these kind of eventualities before they occur, and make sure it's done in a timely manner, so it doesn't impact myself or my family in the future.
Yeah, I 100% agree with that. I do think that a lot of people, myself included, work in a reactive fashion, because as you say, something happens and you think, oh, I need to make sure that I'm covered, so that I don't go through that again, or I make sure other people don't go through that again. I think it's certainly why I ended up getting into the work that I do. I'm not an expert in wills or LPAs or anything like that. I actually work as a planning ahead of time consultant, where I can help people really before you to say, this is what, you know, it maybe needs to look like, and actually get the conversation. Because I think one of the hardest things is having those conversations with family. You know, when you sit there and say, I need to talk about what happens if I end up in an accident and I can't make decisions for myself. I need to talk to you about what will happen if I have dementia and I need to go into care, and I need to talk to you about what happens when I die. You know, these are not conversations that family often want to have, and they can be very uncomfortable. So they're the conversations that I have with people. But then me, obviously, you do everything from a legal perspective.
That's right.
And it's really important that people have these documents put in place through the legal channels.
It's so important, and you know, it's more and more popular day by day. The more that we're speaking about it, especially if you go on my Facebook and Instagram handles, you'll start seeing that what I'm doing is, every day at the moment, since last week, I've been putting a little bit of information each day about why is a will important and what it should contain. And I'll do probably something similar like that to lasting powers of attorney next, after I've done the will side of things. And I'll do something else. And all of my information that's on there is just educational pieces of why it should be done, and on what it should contain. Whether they do it through me, whether they do it through another company, it's a case of, make sure you've got something in place, but make sure it's correct, make sure it's done right, make sure that after you pass away, for example, with a will, if it gets contested, the right people are going to be in place to be able to protect it. I did a post the other day, and someone came onto there and goes, oh, just do what my dad did, which was on a piece of paper, put your wishes onto there, get it signed, and then make sure that a couple of people witness it. Yeah, that's fine. You know, if you've got a couple of £100 to your name, and that's all you've got, then yeah, that's fine. Do those kind of things. But once you own the property, once you have some other assets, you want to make sure it's done properly, because anyone else out there can take advantage of you. And especially with times that we're living in at the moment, where there's technology such as AI, people can utilize that to create fraud, and then take over the estate and take it away from the actual beneficiaries that are entitled to it. So to try and prevent that, you want to use a firm that knows what they're doing and will be able to support after you passed away as well. And same again with the lasting power of attorney. Once you've created it, when you're paying us to create a lasting power of attorney, we're taking the full liability of creating that document to make sure it works. We have liability insurance to cover us in case anything ever goes wrong. Touch wood, nothing has ever gone wrong. But if it was, you've got that safeguard to know that we will still be able to fix it for you at no extra cost to you at that time. Because we know what we're doing, you know, we're equipped to do that for you.
Well, we had a conversation previously about wills, so I would say to anybody who's watched it this far and started to hear you talking about wills, to go and search for that. Your name is Jay. Do you and obviously contact details maybe you'd just like to give out quickly?
Of course I can, yeah. So it's Jay Parmer. Our firm is called Paradigm Wills and Legal Services. We're based in Leicester. We cover the whole of the UK. We also have a branch in London as well. My contact number directly to myself is 07 976 851 552. And I'll share my email address and my social media handles with Dale, and she will share that with you when she posts out the video.
Lovely. Well, thank you for your time again, Jay. It's been really interesting to speak with you.
Perfect. Thank you so much for your opportunity as well today, Dale.